biggest challenge is the conflict between the parents. And the more adversarial the parents are, the more difficult child custody cases are to resolve. The more controversial there are, the more resistant one of the parents is to coming up with a parenting plan and parenting time and custody in the best interests of both the children, the more likely that there's going to be a trial. It's more likely that you're going to be doing discovery. And when that kind of course of action, when that kind of case management pattern comes up, there are other tools that we often have to engage that can be very expensive. For instance, we have custody and parenting time evaluations. And these are studies done by a consulting sociologist or psychologist who will do extensive research. They will observe the children with both parents, in both parents' care. They will visit each parent's home. They will speak to the teachers. They will speak to the doctors. If there are psychologists involved, they'll speak to them. They will do exhaustive research, talking to friends of the family even and other family members to try to drill down and see what the real circumstances and facts are regarding the history of each parent's involvement in the child and their ability to parent. Sometimes there might even be a custody and parenting time evaluator might order a psychological evaluation of one or both of the parents. If there's a suspicion of chemical dependency, they will order what's called a Rule 25 chemical dependency assessment, and they will also order hair follicle tests and fingernail tests to see if that parent is using. So those types of consulting arrangements come into play. They're very expensive and they take time. If your child custody case is very contentious, it could take a very long time to get a final resolution. Now, fortunately, there are temporary motions. So I'll give you an example of a case I just had. There was a couple of parents. They had a child between them. They were never married. The existing parenting time was equal parenting time. All of a sudden, the mother, who is not my client, decided that father really shouldn't be seeing the child that much and started withholding parenting time. We went to mediation. Mediation didn't resolve it. The opposing counsel advised her client not to accept the agreements that were proposed. And so we had to file a temporary motion. We filed a temporary motion, and within 2 months of the mediation, we were before a judge. And the judge looked at all the facts, looked at all the allegations of interference with medical care, medical treatment, issues with the father's house, my client's house. And we filed very detailed pleadings. And after a brief conversation with the judge ordered equal parenting time. So even though we don't have a final disposition, within 2 or 3 months, this father is back to ground zero, where he started out having equal parenting time with his son. And I'm very confident that if this case goes to trial, which now in light of that ruling it may not, we'll be able to keep that order in place. And of course, the court ordered one of those custody and parenting time evaluations that I talked about before. And so that's going to be the next step of the process. But meanwhile, there is a way to get to see your children pretty early on in a case if somebody is keeping them away from you.